they say if to do was as easy as to say, then all poor would have lived in palaces. But are there any proper ways to succeed in life? That is very perimeteria, or as they say, some people believe that it is pure luck. But normally, when we find, they say that hard work is the key to success. But as we had the previous webinar with Mr. Uday Holla, the resource person for today and the speaker for today, he said that if you have to actually succeed, then you have to work very hard and not work, and you should not be working hardly. And during all this endeavor, as I said that earlier, always it was the key to success mantra was work hard. But with now today's changing scenario, we also say that you should work hard, but you should also work smart. And what is the difference between working smart and hard working is also success. But as a professional, and more specifically in the profession of law, we find that there are various nuances which one has to learn to create its own niche and space within the competitive world. And normally as a lawyer or a student, we always find that research becomes a very, very critical analysis for the purposes of while you are studying as a student of law and also as a profession as to what should be researched. And then there has to be an introspection of analysis as to how one should put across the things. And for a student, you have to write things. And for a lawyer, they say that you have to draft well, what is called as writing skills and the drafting skills. And then there are submissions to be made before the court. And consequently, we felt that if we actually put it across all the three words, that is research, R for research, A for analysis, and W for writing skills. What is the way forward if you have to create your space within the entire competition? And what is that particular difference, as they said, when Neil Armstrong had kept his first step on the moon, it was sent a giant leap. And whether there are certain giant leaps within the society to create a difference from an ordinary to that extraordinary person. And we thought when we had a tie-up with Gemtech College of Greater Noida Law College, that we should bring someone who has created the benchmarks within the legal fraternity and beyond. As they say in the common parlance, one who is a good lawyer, they say that where there is a law, there is a flaw. And where there is a flaw, there has to be a lawyer. And down south, at least in Karnataka, they say that when it has to be a lawyer, then it has to be Mr. Uday Holla. And we thought, why not ask from a person as to how one could create that particular mark within the society. They say that you have to strike when the iron is hot. But what is the right temperature and at what stroke it has to be hit are also the lessons to be learned for a profession. Before I request Mr. Uday Holla, a senior advocate from Karnataka and a former Advocate General 4 times, which itself, they say, itself is a benchmark created within the Karnataka itself. And there are rare chances. We have out in Punjab, Mr. Hava Singh Hooda and Mr. Mathewal, who were Advocate Generals from time to time. I know that as a professional, that Advocate General means something very, very special in the profession. Just like they used to say when VVS Lakshman was playing, he was VVS meant very, very special. Same way, the Advocate General is a very, very special place for being a constituency. And I would request Ma'am Palvi Gupta to introduce the college with whom we have being a knowledge partner for today's session, and the students want to learn from Mr. Uday Holla. And then we will request Mr. Holla to take things forward. And we will have the question answer sessions that can be posted on the chat box. And since we are also live on the YouTube as well as Facebook, the questions can also be taken from that place. Over to you, ma'am.
Thank you, Vikas. Good evening, one and all over here. First of all, I would like to introduce my college. The GIMS Educational Group has a legacy of 25 years in a quality education and creating industry-ready professionals. JIMS Group has set up various sister educational institute in all corner of Delhi and NCR. It has 2 universities in Jaipur and Bahadurgarh, Haryana itself. Jamtek School of Law is established in 2014 to imparting legal education by starting 2 programs, BLLB and BBLLB. Jamtek School of Law is in Greater Noida. Under this institute, we are offering other professional courses as well, BTech, BBA, BCA, BEd, BCom, BGMC. Our student has participated in various national and international events. For example, client counseling, national moot court competition, model United Nations and all. So many. Our law alumni are working in various reputable law firms like Pavan Duggal, Associates, and they are working in Delhi Legal Service Authority and so many. Today's topic, as very well Vikasji tell that it is the research, analysis and writing arguments. For a successful lawyer, it is very important that he should be a good researcher, analytic. Besides this, they must have argumentative skills as well. And how a law graduate can become a good advocate. For this, today we have Mr. Uday Holla, Senior Advocate, former Advocate General. Welcome you, sir, over here. About the advocate Uday Holla ji, he has graduated from the Renukacharya College of Law in Bangalore in 1973. In 2018, he has appointed as an Advocate General for Karnataka. He has been Advocate General of Karnataka for the 4 occasions. On behalf of Jamtek School of Law and Beyond Law CLC, I welcome you, sir, in a series of national webinar. Welcome you, sir. It is my privilege to welcome you, sir. I think association of 3 cities, Chandigarh, Greater Noida and Bangalore, it will coming together for a good cause of dissemination of legal knowledge. It will be definitely fruitful for us. I hope your deliberation on the today's topic shall be beneficial for all the participants. With this, I welcome you again. Without taking much time, I now audience back to Vikasji.
Sir, you will have to unmute, and since people are all willing, yeah, you will have to unmute yourself. Unmute. Yes, sir.
Okay. Well, ladies and gentlemen.
So slightly, you will have to place the camera down. Your full body is not forthcoming.
Okay.
So you can go. So you can go.
Yeah, no, it's fine.
I think that I came forward to be amidst the students because
no, we always look forward to you.
See, a profession of law, I've always said this. It's a service-oriented profession. One. Secondly, it is a thinking profession. Most of us have forgotten that profession of law is a thinking profession. If these 2 aspects of the profession of law are borne in mind, I think many things fall into place. Whether it be hard work, legal research, analysis, ability to think on one's feet, drafting skills. Legal research is one of the important facets and aspects of the profession of law. I'm sure many of the students, if you go abroad, you have classes on legal research and analysis. Unfortunately, in India, the curriculum does not provide for it. It's a very, very important aspect of the profession of law. Because when you carry out legal research, it's about learning and knowing about law. Now, what are the steps that one is required to take with regard to legal research? People come with their problems to a lawyer. I'm sure the students during the moot court competition do a lot of research. And today, thanks to the internet, thanks to the computers, most of the students I find are savvy and they do a lot of research. What are the steps that are required to be taken for completing this legal research? People come with their problems. If you are a litigating lawyer, they come with some problem relating to some litigation. If you are a corporate lawyer, they come with some issue relating to corporate laws. In both these instances, one is required to collate all the facts first. The first step in legal research is to collate the facts, to collect the facts, to find out what are the problems that exist, what are the issues that arise. Once you collate all the facts, in fact, I can tell you this, when a client comes, he may not know what are the facts that will have to be dilated or explained to the lawyer. Ultimately, the lawyer, when he knows all the facts, he will be in a better position to give succor to the client. Therefore, one is required to collate the entire facts relating to the problem. Secondly, one is required to identify the legal issues that arise out of those problems. Thereafter, one is required to identify the source of law. There may be statutes, there may be rules, there may be regulations. Now, all these are spread across the length and breadth of the internet today. Once you identify the legal problem, then you will have to identify the statutes and the regulations which have a bearing on the problem that is before you. Then you start the legal research. You identify the statutes, you identify the factual matrix. Thereafter, you do the legal research by going into the various books or into the software that have all the books compiled in them. Thereafter, you will have to analyze. This is one of the most important steps that one is required to take. After identifying the problems, after identifying the issues involved, after identifying the statutes and the regulations, after doing the research, trying to find out what are the case law that exists, either in your favor or against you, you are required to analyze those case laws that exist. Not only should a lawyer be aware of the judgments that are in his favor or in favor of his client, he must also be aware of the judgments that can be cited against him. Many a times, it is more important to know what are the cases that exist that may be held out against you. And you must be able to distinguish those judgments. The analysis is what actually assists you in analyzing these case law, trying to arrive at the solution to the problem that exists. And ultimately, you have to either give the draft written submissions or the oral submissions. Now, under the Commercial Courts Act, Section 18, there was an amendment in the year 2020, whereby in respect of commercial cases which come before the commercial courts, lawyers are required to submit written submissions setting out the factual matrix, the legal issues, and the decisions in their favor. And 30 days before the oral submission, they are required to submit it to the court. It is thereafter that the court will hear the oral arguments. Of course, the same thing may not apply to the other kinds of litigations which exist in other courts of law. But commercial courts today the statute itself mandates that you are required to submit written submissions. I am reminded of what the decisions, some of the decisions of the Supreme Court. Drafting is it's an art and a skill. In 2002, Volume 8 SCC 237, in paragraph 57, Supreme Court had an occasion to deal with the statutes. That was a reference made by the President of India to the Supreme Court. And in that context, the Constitution Bench of the Supreme Court had this to say: drafting text of a statute or constitution is not just an art, but is a skill. It is not disputed, is what the Supreme Court said. It is not disputed that a good legislation is that the text which is plain, simple, unambiguous, brief, precise, and there is no repetition of words and use of surplus language. Now, the same yardstick applies to written submissions as well, which I'll dilate a little later. Coming back to the legal research, as I said, one must be aware of the cases both in your favor and against you. Today, the younger generation are doubly blessed. They are net savvy. They will be able to do research in no time because the software is available. But unfortunately, what happens is people just look at the head notes and think that is the law. It is very, very relevant to make note of the fact that it is the ratio of the judgment, the principle on which the judgment is rendered, that is the most relevant thing that must be borne in mind. And to understand that, the ratio decidendi, if I use the technical language, the ratio decidendi is possible to be understood when one reads the whole of the judgment. Yes, if you read the judgment on its own, one tends to sleep. But when you have a problem in front of you and that judgment has some bearing on the problem that you have on hand, I'm sure you will be able to understand the nuances in that judgment, the legal principles that exist there, and the ratio decidendi. In fact, Supreme Court in 2009, 5 SCC 694, in paragraph 21, has held that precedent is a judicial decision containing a principle which forms an authoritative element termed ratio decidendi. To put it in a simple language, or in my own language, ratio of the case is the principle on which the case is decided. As all of us know who have been in the profession, and possibly the youngsters, the students who are today in the field of law, who will be the future generation of lawyers, the Supreme Court has time and again held that not everything that the judge says is the ratio decidendi. Not every observation. It is the principle on which a case is decided that is the ratio decidendi. And many a times, facts lend color to the judgment or the decision. Even a small fact, a single fact may change the principle on which the decision is rendered. It is in this context that the Supreme Court held in 2002, Volume 4 SCC 638, in paragraph 7, that what is binding is a ratio of the decision and not every finding of fact. It is a principle found upon a reading of a judgment as a whole in the light of the questions before the court that forms the ratio, and not any particular word or sentence. In fact, in 2011, and there are earlier judgments as well. 2011, 5 SCC 708, in paragraph 32, Supreme Court has held that one or additional fact may make a world of difference in that conclusion, and that while applying the ratio, court may not pick out a word or a sentence from the judgment divorced from the context in which the question arose. Therefore, ultimately, after analyzing the facts, after finding out the judgments in your favor or against you, one is required to analyze the judgments, to find out what is the ratio, what is the principle on which the decision is rendered. No doubt, many a times, if the factual matrix in a particular case are similar to your the problem that you have on hand, judge will start eating out of your hand. That is why it is said, a lawyer's work is like a detective's work. From small leads, one goes further and further and arrives at the final conclusion. It is that hard work that makes or mars the professional. As I already said earlier, hard work takes the man or the woman in this profession to the top. And analysis is possible when you start thinking. That is why I said in the initial stage itself that this profession is a thinking profession. One has to think hard and deep. One also has to think out of the box. I've always said this whenever I have spoken, that management principles must be evolved and adopted in our profession. In fact, many of the management principles help the professional in trying to convince the judges, in trying to collate facts. It encourages him to be more disciplined in his work. I would recommend to youngsters, the students, to read some of the books on management consultancy. In fact, management principles, if it is adopted and evolved in your own profession, you will shine better. Research, as I said, is a basic element of the profession. And once you carry out the research and you carry out the analysis, then you start writing. Writing, as I said, is an art and a skill. Many a times what we do is, we think that bombastic language, very lengthy arguments, written arguments will impress a judge. On the contrary, the whole idea of written submission is to ensure that the learned judge before whom you are there is able to understand your problem, the legal nuances which arise in the problem and in the case at the earliest. So one must use simple language, straight, short sentences. One must be precise. That's the reason why in that judgment in the Supreme Court in 2002, 8 SCC 237, paragraph 57, Supreme Court held, and that equally applies to the professional when he prepares a written submission. It must be plain, simple, unambiguous, brief, precise, and no repetition of words or use of surplus language. Ultimately, why are we submitting a written submission? It is to ensure that the judge is able to understand your case. He gets a brief idea of your case without spending a lot of time. In High Court especially, or even in the trial court, with the proliferation of cases, judges don't have too much of a time on hand. They have a number of cases on hand. So if somebody is able to make the learned judge understand the problem, understand the case law, understand the nuances on a case, at the earliest, he will start eating out of your hand. And that is what a lawyer must do. After all, in High Court, today I had a case. How many cases were there? It was about 110 cases before this particular judge. Imagine his plight. If I have to start arguing, giving him, the problem in a very lengthy manner, he will start getting irritated. Therefore, the only way one could help him understand the problem is to be brief, precise, and concise. I have said this many a times, that when you have a case in the High Court or even in the trial court, try and prepare a list of dates, which also encapsulates in itself the synopsis. If you prepare a list of dates, then it becomes easy for the learned judge to understand the problem that is before him. With the list of dates, which also encapsulates in itself the page numbers, the annexure number, he will be able to pick out the relevant documents without much of an ado. Therefore, one of the things I've always recommended is, after you carry out the research, when you prepare written submissions, have a list of dates, which should not run more than 3 or 4 pages. In fact, in the Supreme Court, list of dates have been in vogue for the last several years. In Karnataka also, since the last 4 or 5 years, that practice has been adopted. In a writ petition or in an appeal, you are required to file the list of dates and synopsis, which is filed along with the writ petition or the appeal memorandum. So this is what we have to do. Written submissions must also be very brief. It must be succinct. It must be brief. It must not contain passive sentences. Always use active sentences. One of the mistakes that we lawyers always do is write lengthy sentences, write passive sentences. This should be avoided. It is, as I said, the entire attempt of the lawyer is to ensure that the judge is convinced in the shortest possible time. And if you do that, he will really appreciate you, because he does not have the luxury that judges of, say, 3 decades back or 4 decades back had, with 2 crore cases spread across the length and breadth of the country, with lakhs of pendency in the high courts. Judges would always appreciate when you give written submissions which are short, but at the same time encapsulates the entire factual matrix as well as the legal matrix. One of the things that always the judges insist is, give a written submission not more than 3 to 4 pages. In fact, in one of the cases, I was just doing some research. In fact, I had also appeared in a connected matter. In Jayalalitha's case, the matter went. Jayalalitha was the chief minister of Tamil Nadu. She was prosecuted. Matter went to the Supreme Court. In 2015, volume 6 SCC 158, the Supreme Court had an occasion to deal with that case. What happened was, a special prosecutor was appointed, and the petitioner who was prosecuting Srimati Jayalalitha went before the Supreme Court and challenged that appointment of the special prosecutor. In the context of that judgment, Supreme Court noted that before the trial court, written submissions and written note was running into 400 pages. And Supreme Court permitted, matter came, was remanded back to the High Court because the matter was pending in the High Court where the special prosecutor was appointed. And the Supreme Court directed that or permitted the petitioner to file submissions running to 90 pages. And State of Karnataka, which was a prosecuting agency, because the matter got transferred from Tamil Nadu to Karnataka because she was the chief minister. So they said, State of Karnataka will file a note of 50 pages. Now imagine the plight of the judge reading about 600 pages of written submissions, apart from the volumes and volumes of paper books. So when you file written submissions which are brief, you are always greatly appreciated. Now, with regard to this analysis, how does one analyze? One has to think deep. Let me give you one illustration. Recently, I had a matter where Section 28 capital A of the Land Acquisition Act, which entitles and enables persons who have not challenged the award to get compensation, higher compensation, based on another award which is given to another person under the same notification. We argued the matter. After the arguments were over, I was at the stage of reply. I again read and reread Section 28A. One of the things that a lawyer must always do is read the statute, read the sections over and over again. You will get newer nuances. You will be able to identify different facets of that particular section. That is what I did. In fact, it is said, one of the juniors of Sri Parasaran, who's today an additional Solicitor General in the Supreme Court, he was telling me that that great judge, lawyer, he has 50 constitution books. And his junior told me that every time a problem comes with regard to the constitution, he will take out a fresh book, read that section or the article. Why? Because every time he reads that particular article, he looks at it from a different angle. Every day, we become wiser. Every experience that we encounter or we experience teaches us newer things. When you sit in a court, listening to somebody, you will learn so much, both with regard to the decisions as well as the way they put across things. So every day you become wiser, and every time you look at the section, you will get newer ideas. And ultimately, as I said, one must also, as lawyer, one must also be able to think out of box. That is, be innovative in your thinking. Once you adopt these principles, I'm sure it becomes a part of you. You look at a particular section from different angles. You will unearth different nuances in the said section. After all, statutes form the basis of many of the litigations. And when you look at the section every time, and based on the experience that you have over the years, you will, I am sure, you will find newer insight into a particular section. Ultimately, after all this, you are required to make your submissions in a court of law. What is it that you have to do? One other things that in the moot court competition that we find is you start thumping the table. That is not done in a court of law. After all, as a professional, your attempt should be to ensure that your client becomes a hero. As a professional, your client's case must be put at its highest. And if you berate a judge, will he give you an order? Certainly not. Therefore, one must always be courteous. After all, courteous to the other side, courteous to the bench. Courtesy begets courtesy. And when you are courteous, when you are fair, judges also will respect you much, much better. They will listen to you with better appreciation and greater attention. Therefore, these are the things that one must always remember. In the submission, be brief. Like the written submissions, you must be precise, concise, and you must also be very courteous. After all, if you are not courteous, if you start berating the opposite side, you will get it back in the same coin. The resultant position is that you will get angry. The moment you get angry, you'll start forgetting what is required to be stated in a court of law. One must always be cool-headed. And to be cool-headed, one must be very courteous. I've always said this. Humility should be the hallmark, and I've said this also. Arrogance is that of the dictator, while humility is that of the great person. Be humble. After all, as a lawyer, your attempt should be to ensure that your client's case is put at its highest. And when you are humble, you will adopt many, many things, including hard work. It comes automatically. Submissions must be, as I said, precise. You must be articulate. Language is also very, very important. After all, English, it's not necessary that you must be very articulate in English. You could argue in Kannada or in Punjabi. I'm sure in the lower courts, the lower judges appreciate when you mix English with the local language. When you cross-examine a witness, I'm sure local language is always used. So you must be familiar and eloquent in your submissions as well. Articulation is also a very important aspect that one must bear in mind. Now, these are the aspects which should be borne in mind. Ultimately, what is this profession all about? It is to ensure that justice is done to the litigant. And to do that justice, one must strive hard. And after all, I have said this on an earlier occasion, when you go to a doctor, you would want him to treat you well. When you go to a dentist, you would not want you to take out the tooth which is not in need of extraction. So when some client comes to you, you must bear that in mind and give him all the succor and all the hard work that is expected of you. That is what is professionalism all about. Ultimately, in the profession, legal research, analysis, written arguments, and submissions are the core of the professionalism of this legal profession. Unless you imbue all these things, you will not be successful. If you are able to master all this, I'm sure the sky is the limit. The profession at the top, there is a lot of space. All that one is required to do is hard work, think. The ability to think. In fact, if you just go into the net, go into some of those universities in the US, there are subjects on thinking itself. That's why I said legal research, we don't have subjects. Analysis, we don't have subjects in our law college. Thinking process, no subject. I wish management principles being evolved and adopted. We don't have subjects in this. I'm sure a stage will come when all these subjects would be introduced in the law colleges, and I'm sure the future lawyers will have a better ability to give succor to the litigant public and also to the corporate world. Now, I spoke only about the litigation. Even for a corporate lawyer or an in-house lawyer, legal research is very, very important, because unless you know the law, you will not be able to guide your corporate clientele. Unless you know the law, the in-house lawyer will not be able to guide the company or the officials in that company or the firm or the entity where he is working. Knowing the law is very, very important. If you do not know the law, in fact, one of the things I've always said is, when a client comes, first thing that you must do is, after ascertaining the facts, before you draft out a plaint or a petition, you must know the law. If you do not know the law, you many a times you make mistakes. Earlier in the Specific Relief Act, section 16C of the Specific Relief Act specified, it's now amended recently. It specified that a person, that is the person who seeks specific performance, must ever and plead and prove that he was always ready and willing and continues to be ready and willing to perform his part of the obligation. If this pleading was not there, the petition or the suit was liable to be dismissed. So lawyer must know what the law is. If the lawyer does not know that there exists a section by name section 80 of the Civil Procedure Code, and that when you file a suit against a government, you have to issue notice, wait for 2 months, and then only file the suit, you will not be able to comply with that requirement. And if you don't comply with that requirement, suit is liable to be dismissed. Therefore, knowing the law is very, very important. As far as the corporate lawyer is concerned, when it comes to a transaction, when he drafts out documentation, he must know the law. Unless he knows the law, he will not be able to draft out the documentation properly. If he knows the law, he is in a better position to draft out the documentation. As I said on the earlier occasion, Section 108 of the Transfer of Property Act sets out various obligations and responsibilities of the lessor and the lessee. If you know it, you can adopt all that into your petition, in your lease deed. Similar would be the position in relation to sale deeds or in relation to, say, any transactional documentation. So knowing the law is very, very important. And if you know the law, then only drafting is what should be resorted to. Acquire as much knowledge or legal aspects with regard to the law and the problem, then you are in a better position to draft out documentation or in a better position to draft out the transactional documentation. I think I have crossed 45 minutes. I think there's a question and answer session. More than an hour is, too boring. Therefore, I wish and hope that I'll be able to answer some of the questions from which I also will learn, because younger mind will always have a better insight. They have better ideas. They'll be able to ask, more questions which we have not even thought of. So many a times when I interact with the youngsters, it benefits me also. So this is what is about legal research, written arguments, analysis, and submissions. I wish, and hope that some of the youngsters, this talk will help them because they are the future of the bar and they are the judges. And I'm sure many of them will be in the Supreme Court in hardly about 2 decades from now. Well,
yes, sir. Thank you for the insightful inputs. As you rightly said, there are questions, and one question which normally also comes in the mind of a lawyer is, how do we read a lengthy judgments? Where do we start from? Kindly suggest some methods of research, maybe authority, section-wise, of conflict of law. This is by Nitika Modi. She's probably from Bombay.
Yes. 2 things are there. One is, we had, I'm sure, now it is not there, I believe. Wren and Martin grammar book was there for English. One of the topics there was pre-C writing. The 4-page essay will be given to you. You will be asked to scale it down, encapsulate the same thing into 2 paragraphs or 4 paragraphs. 4 pages to 4 paragraphs, say 1 page or even half a page. That is what you must learn. That is the art and skill that one must always evolve. From practice, one will be able to do so. Second, with regard to the legal research, there is what is known as an AAR manual. This is what I've always been telling all youngsters. AAR manual has all the enactments, and in some, if it is a shorter section, in hardly 2 pages, you will have the judgments for and against you in snippets. Once you read them, you know what the law on the subject is. Thereafter, take out the books and then, you can do more research. So AR manual should be our friend. Library should be our best friend. Today, fortunately for you, all the books are there in the internet. You can access the best of the libraries, whether it be Harvard Library or Yale Library. You can access them. You can access in the United States, you have some of the most wonderful libraries. You can access them. But for a lawyer in India, AR manual should be a friend. Take out that. Supposing there is a problem with regard to the Specific Relief Act, Section 16. Just take the AR manual. In hardly 10 pages, you will have the entire case law in snippets, both for and against you. And once you read it, then you can do more research. So this is how we do. And once you take out those judgments, read the judgment, find out what the ratio is. Ultimately, ratio is what makes a judgment, the principle on which the judgment is rendered. If you start reading the judgment in full, you'll be better off. Many a times, short notes or the head note are misleading. After all, head note is not the judgment. Head note is what some author or somebody sitting in some corner thinks, is the essence of that judgment. One must read the whole of the judgment. AR manual, and not only that, please also bear in mind, many a times, the judgments you cite may have been overruled, or there may be other judgments which have followed this. So there are what is known as citations, citators, which will, supposing there's a judgment of say 2015 6 SCC 158, I said where Jayalalitha's case was there. Would that have been followed? If you look at some of those citations, in fact, in the SCC online, if you click on a particular button, it will set out all the judgments which have either followed or referred to this judgment. That is, you learn. The citations, today, that kind of a thing is very less, but there are books. In fact, Sri Gopala Krishna he is no more. He was one of the stalwarts in the Supreme Court. He had written several books where judgments which are followed, overruled, distinguished were all set out. So this is how you do the research. Yes, sir.
As you rightly said, though nowadays telegrams are no longer into existence since the SMS and WhatsApp came. We had one judge who used to say, "Don't read the telegram, read the full letter," because telegrams can be misleading. This is by Sheena. She says you had highlighted the importance of thinking out of box. What kind of research should be done for making out of box ideas successful in a case where there are no previous precedents?
Well, thinking out of the box is what? Thinking innovatively. One must think deep, one must think hard. You will get newer ideas. That's why, I gave you the example of Sri Parasaran. 50 different constitutions. Once he completes it, he leaves it. He takes the next one, looks at the article. Every time you look at the article, Article 19, let me give you an illustration. Article 14 is discrimination. If you look at the judgments, Article 14 merely says that one person will not be discriminated against the other person, or the state will not discriminate between two persons who are equally stationed. Supreme Court dilated on that. If you remember, it said arbitrariness is a part of Article 14. Unreasonableness is a part of Article 14. This is again thinking out of the box. Why? This was done to ensure that succor is given to a litigant. Many a times, the judges also think out of box. After all, if you look at the judgments, there are innovations. There are leapfrogging of the thinking process, which is evident when a brilliant judge is there as against a state judge. So this is what you must do. This thinking out of box is something which you will have to adopt and evolve. It is only by practice that you will, start imbibing that process or that character. I'm sure if one thinks deeply, one would be able to think out of the box. After all, when clients come, they'll have different things. They'll have different problems. Now, when you want to reach Delhi, you can reach Delhi through Nagpur. You can reach Delhi through Bombay. You can reach Delhi through Calcutta. If you think that there are certain hurdles by going straight to Delhi, you can go via Calcutta. Thinking out of box is that, trying to be more innovative. After all, innovation is a part of every lawyer's life. When you have a formidable opponent against you, you always think as to how to beat him out. After all, I've always said this also, it's like a chess game. When you have litigation, it's like a chess game. How do you play chess? You always think. And, you think at least, 5 or 6 moves ahead. How do you do that? Again, thinking out of box is needed. These are things which once you evolve adopt this methodology, you become a past master in it. Yes, sir.
Since you have created your own space, a lot of people do believe that since you have 5 years, decades of practice, and you have created your own name, what are those essential skills or knowledge that you credit the most for having contributed your standing in the bar? And if given opportunity, or if you look into yourself in a retrospective manner, what things you feel that you should have done at that particular moment of time that you could create a more particular space?
I wish I had stopped, because see what happens is I'm very fond of writing. Even now, when some lawyer comes, and gives me a draft, I keep correcting it. I only wish I had not done that, because I would have had more time to think. I would have more time to do legal research. I would have more time for myself. This is one regret that I have. But then I felt that I owed it to the younger generation, that I must correct it so that they learn from it. This is what I did. And let me also tell you this, when your belly is on fire, it will come up. I think I told you last time, I did not have money. 6 months I was with the lawyer, not 1 rupee was given to me. So these things, will make you do things to ensure that you survive. I've always said this. I've always admired Punjabis. Why? Reason is simple. All the Muraidas came through Punjab. None of us, none of them came via the South India. So you are always more, innovative. You are always more aggressive. You are always, you always think far ahead. Whereas in South India, we will be very happy with a buy two coffee. We will be very pleased. So this is what happens when you have the difficulties, difficult situations. You definitely overcome that. What is it that I did? I wish I had more time for research. I wish I had more time to interact with the younger members of the bar, or the students especially. In the last 10 years, I've been going to the colleges, but before that I didn't, because I thought I was too busy. In the last 10 years, whenever, wherever a college asks me to come, I readily go there, because ultimately they are the future of the bar and they are the future of the country. I wish I had done that, not 10 years back, but ever since the beginning. I didn't do that. That is one regret I have.
So that regret we will not allow you to continue, because on this platform we will keep on calling you. And this way, that will not be only restricted to Karnataka down. Now, pan-India people will learn from you. And then, what do you think that the young lawyer should focus? Because they say it's all wavering for the first 5 years, the practice. They say that, as you said, they should be in the belly. But I also remember we read a story. There were a young couple who wanted to marry, and both of them were not earning. Then another person asked, how will you survive? They said that love is in the air, we will do that. But eventually they had a divorce because their entire hustle because there was nothing to eat, etc. So that they said love is there, but you also have to have something to eat also, because you can't survive only on the love. So what do you say that young lawyers must focus for the initial 5 years? And what are the skills they must pick up initially? Because they say at the first stage, as they say, foundation should be strong. In law also, we say that if the foundation is weak, the superstructure falls. So how to build that foundation for a better superstructure of tomorrow for India?
One of the things that a younger lawyer must always do is read. Library books should be your best friend. Knowledge is what you must acquire. After all, it is this profession, apart from being a thinking profession, is a knowledge-based profession. I have handled air crash inquiry, where I had to study about aerialons, black box. 6 months I had to study not law, but how all this plane flies, what happens to it when it crash lands, how is a black box red. So you must have a general knowledge as well, not just law books. I have handled, as Advocate General, litigations relating to the interstate water dispute, where I had to cross-examine a triple PhD, where I had to cross-examining on scientific principles. How did I do it? I sat with some of the retired Indian Institute of Professors from 6 o'clock to 12 o'clock in the night. 12 to 3, I would sit on my own and think how I could cross-examine this person based on the knowledge that I had acquired. So what you must do is, as youngsters, first thing that I've always said is, be a litigating lawyer at least for about 2 years. You are better off as a transaction lawyer, because you know what are the pitfalls in drafting out the transactional documentation. After all, there are cases where, in fact, I had one matter where 1 cent in respect of a power purchase agreement, 1 cent was the issue. One of the Singapore-based company had drafted out. It was running into about 250 pages. This 1 cent translated to 1,000 crores. Ultimately, we went into litigation. Matter went in for arbitration. There, the lawyer in Singapore did not know what mistake he had made, because he had no experience of litigation. If you have some litigation experience, you know what are the pitfalls. So you are better off. 1. Second, join a firm where you are able to interact with the senior. That is very, very important. The old Gurukul system. After all, what you learn in the law colleges and what you practice are totally different. I'm sure many of the youngsters today have learnt about it because they come for placement and go to courts, which we did not have that privilege. So interaction with the senior is very, very important. Third, drafting skills. This again is very important, because when you start drafting, when you are precise and concise, your arguments also will be precise and concise. So try and understand how one can draft. One of the things that always, the mistake that youngsters do is they'll draft out and then give it to the senior. Well, let him do what he wants. One must always revise the edition. Revise the draft once, twice. Let me tell you this. I don't want to name the judge. One of the really good judges that Karnataka sent to the Supreme Court, who is now today a retired judge, he was revising his own judgments at least twice. And when it came out, it was so crisp and clear. Look at the Privy Council judgments. They are so crisp. Why? Because they revised it. So, as youngsters, this revision, trying to be perfect, trying to achieve excellence, this is what you must aim at. Once you do that, I'm sure, the sky is the limit. You will go to the top.
So since you have been focusing a lot that you have to read, so any youngster maybe who has not been all are not lucky enough to join your office, how do you suggest him that what should be the rough draft of a written plaint or a writ petition to be drafted, and then if you have to file a counter, what steps he or she should keep in mind while doing that?
First thing that a lawyer must do is, sorry.
Yes, sir.
First thing a lawyer must do is try to find out the law which has a bearing on the problem. If you know the law, you are in a better position to draft out the petition or the plaint. After all, adverse possession, as all of you know, if a person is in occupation of a property for 12 long years, he can claim adverse possession against ordinary individuals, and if it is more than 30 years, against the government. One of the things that the law with regard to adverse possession is you can't claim both ownership as well as adverse possession. The moment if you do not know that this is the law, you make a mistake when you draft out a plaint. If you know the law beforehand, you will draft out the plaint or the writ petition in a more precise and in a more legal framework. That's why I said Section 16C or the Specific Relief Act. Had I not known about it, I would have drafted a plaint without averring or without pleading that I've always been ready. My plaintiff has always been ready and willing and continues to be ready and willing. Without that pleading, the plaintiff is liable to be dismissed. Of course, there's a change in the law now that averment, is not needed, but that is what it is. Try to understand the law, then you are in a better position to draft out. One. Second, plain language, simple sentences. Every paragraph must contain one idea. Don't make too lengthy a paragraph. I have seen lawyers drafting out, their paragraph will run into 2 pages, 3 pages. Judges will not have the time and the patience to look into that kind of a pleading or a draft. Make it short, precise, concise. Break it into shorter paragraphs. Each idea in one paragraph, you are better off. So this is how you learn. Interaction with the senior, revision of the drafts that you make, improve, try and achieve excellence. Never be satisfied with what you have. Always, go a step ahead. You are sure, I'm sure. In fact, let me tell you this. I was going for karate classes long back. We had to run for 5 miles. After 2 miles, we would feel as if, we will fall down. But if you cross that threshold, we could run, the entire, not only 5 miles, we could run 10 miles. That is what it is. Never give up. Always, strive hard and say that you are able to achieve the top. You will achieve the top. It is that ambition, that innate belief in yourself. That is very, very important. Every person can reach the Everest. It's not that people, today, people who have lost one leg have gone to the Everest. There is one, if you just get to the net, you'll find out. I have already said that earlier also to you. Stephen Hawking, one of the greatest thinkers that the world had, astrophysicist, he was on a wheelchair. He had a voice synthesizer. He couldn't speak. Yet, he wrote several books which were masterpieces. So, to the youngsters, I would say, have belief in yourself, try to achieve excellence, work hard, have your hands clean, never, sully your hands. Ultimately, one must be able to sleep well. And if you cheat somebody, you will not be able to sleep well. So, bear this in mind. Have ambition. Go to the top. You are able to do it. Always, focus the top. Focus at the top. You will climb up the ladder without any hassle.
So according to you, the mantra would be, if you believe, then you can conceive. And if you can conceive, then you can achieve.
Correct. Absolutely. You put it very, very succinctly. That is what is precise and brevity is. That is what is needed from a lawyer.
No, they normally say that as a lawyer.
The illustration, which I did not. I'm grateful to you. And I'm sure the youngsters are grateful to you.
No. Because they always say that there are only 3 principles for being a successful profession. One should be concise, and precise. Yeah. Sir, what are the important skills that one has to set in the mind as an arguing counsel? Because they all say that the lawyer is one who can write 100 pages and still say it's a brief. So how do you believe that one should make it a short, crisp? Because they say, if we read a lot of books, they say that any good skill is you have to say it like a kiss. Keep it short and simple. So what is your take? Because while drafting it, you take up team number of points, but how do you funnel it across and put it across that this should be the best point put forward? And how do you read that psychology? Because they say that every judge wants to place the things in a different way. One wants that the facts should be called out. One says simply come to the impugn order. One says you buttress your argument with a judgment. So what is your take on that?
Let me just tell you this. One of the mistakes that youngsters do is, if you have to file a petition under 482, you file a petition under 482 for quashing a criminal complaint. One of the mistakes that I find that many youngsters do, and I've always corrected them, they will first set out in the complaint, this man said this, all the gory incidents set out in the complaint, they'll put it out in the beginning itself. And thereafter set out what's the defense that you have. When a judge reads that draft, Will he be able to, give you some kind of a succor? On the contrary, in the beginning, you have to plead and set out why this complaint is not, what are the factual matrix with regard to you, which are the true facts vis-a-vis you, and how you have been innocent, and then set out the complaint and say that, this is how, it has been set out in the complaint. This is one. Second, when you make your submissions, that's why I said thinking process is very, very important. You must encapsulate. When you paint, how do you paint? You take a canvas. Will you paint, take the brush and start painting, or will you envision an idol or a figurine or something which you want to, paint on the canvas? Mentally, you think, what is it that should get into the canvas? Then only you start painting. That is how, a lawyer must also do. One must look at the facts. One must be thorough with the facts, thorough with the law. One. Second, it is said Churchill was one of the greatest of speakers that England had. And yet, he would go in front of a mirror, and before some important function where he had to speak, he would go in front of a mirror and practice it. In karate, they tell you, do the katas. Katas is that dance form where you imaginary, 5 people attacking you, and you do all the way you ward off, the kicks and the punches and all that. So you do that in front of a mirror, you'll start improving. This is how you must do. You must think, what is it that I am required to tell the judge? In what manner can I put it? Can I put it in a simpler manner so that he understands it at the earliest? Precision, conciseness, and at the same time, it should be complete in itself. That is where pre writing. The same thing, when you write, the same thing should be adopted in your submissions. Second, as I said, have a list of dates. I remember a case where before the Supreme Court, a very heavy matter came up. I gave them a 3-page note where I set out, the factual matrix and the law, just a 3-page note. They started eating out of my hands. So this is what you must do as a arguing counsel. You must be precise, concise. Think what is it that you must say to the judge. Also, you must also anticipate what arguments can be canvassed from the other side and must have answers for that. What questions can be posed by the judge? This is also very, very relevant. Many a times, like a chess move, chess game, you must think ahead. When you have a case, you can anticipate some questions coming from the judge. You must have answers ready for it. Then the judge will eat out of your hands. So these are the things. Ultimately, each person is unto himself. Depending on the judges, depending on their psychology, you change your arguments, the ability to, what you put across, whether it is factual matrix, whether it is law, because some judges don't like, citing of citations. If you keep on citing citations, they'll say that, look, don't do all this. I know what the facts are. Tell me the basics. Tell me the fundamentals. This is what they do. So depending on the psychology of the judge, you must also change. Yes, sir.
This is where Rishi, since presidential value varies when it comes to an Indian and international cases, how do we ascertain the presidential values of the international case for an Indian case at hand of it?
See, it is international cases. Let me give you one illustration. Recently, I had an arbitration. What was the case? Case was interest. Interest as per SPI on daily basis. So the argument on the other side was, it's a compound interest, compounded daily. I tried looking up cases. There were no cases, Indian cases. I looked up. and I found a judgment of the Supreme Court of South Africa directly on the point, and they said it is simple interest. So international judgments, if they have the factual matrix is the same, you can always cite it. You have, if you look at the judgment of the Supreme Court, some judges, fall in love with those international judgments, especially the House of Lords and all that. So it depends upon it, depends upon the judges. And international judgments, if the statute is similar, can always be cited. If the statute is different, then it may not have precedential value. As far as precedential values are concerned, Supreme Court of India is the first preference. Your own High Court is the second preference. Then, of course, comes the international judgments and all that. But what happens is, when you have international judgments, there may be some newer points in which the judges might have thought of. And some judges will like it very much. That's why I said, you must know the psychology of the judge as much as you know the law. Yes, sir.
In fact, I was told that nowadays in a lot of universities and colleges have also started incorporating psychology. So
Correct.
that you can understand the nuances better. This is why Abhishek, when a situation occurs in life of a lawyer, the time has passed now, and law has nothing to proceed. Then how does the lawyer further proceed? So, like you were saying, it is, one has asked a question, how does one go about developing the arguing skill sets? What are your takes for that?
Arguing skill sets are developed by acquiring knowledge. If you know the law, you have all the confidence. You will not have diffidence. Moment you have diffidence, you will not be able to argue well. If you have confidence, you will be able to argue well. That confidence comes from the knowledge of law. If you know the law in its entirety, the factual matrix, you will have the bravado to argue before any judge. But if you are not thorough with the facts or with the law, then you will, despite your, you may have a false bravado, but then within a matter of 3 minutes, when the judge asks the question, it'll all get dissipated. So know the law, know the facts, read well. Even at this age, even if I have read the brief 100 times, if the matter comes up tomorrow, I will at least brush up my memory by looking at my notes, looking at some of the pages the previous day. That is what you must do. You must never take things for granted. You must always remember that memory always fades. Of course, youngsters will have a better memory. There are some lawyers, who have fantastic memory. But you must always be able to be crisp and be able to point out, pages and annexures without batting an eyelid. Therefore, prepare yourself well. You can, be a better lawyer.
So according to you, empty vessels make more noise than bench will immediately recognize.
Absolutely.
So they say, as they say, that the desire is the first and the foremost things. That the biggest wings are of the ostrich, but it cannot fly because the wing, the desire to fly is not there. Or you can say that it's too heavyweight in that sense. So he or the ostrich also has to learn karate like you do, since I've learned that you are. And so this is the question I have received. Since that day, everybody saw that you were using a lot of palm tops for citation judgments. Or to maintain that diary, whether you would like that it should be year-wise, subject-wise, references-wise, how do you put it across?
You have to put it in the form of different, say, Article 14. In Article 14, there are different headings. It could be Article 14, unreasonableness. List out the cases. Article 14, arbitrariness. List out the cases. Keep it in one place. It need not be, palm top is out of vogue. Since the last 2005, they have stopped manufacturing it. You have to maintain a diary, or keep it in your mobile phone itself. There are notes. There are Evernote. There are, several apps where you can store them. It becomes easy, from there. It's like leapfrogging from there. You need not, reinvent the wheel. As they say, you need not reinvent the wheel every time. If you keep all this, I was giving you the example, Article 14, arbitrariness. Article 14, unreasonableness. Article 14, equals being treated equally, unequals being treated unequally. If equals are treated unequally, it is arbitrariness, or it is violative Article 14. If unequals are treated equally, again, and it's arbitrariness. So different things, you keep setting out and maintaining the diary. There is no hard and fast rule. But why I am using the palm top, or why I would want you to use the apps, search becomes easy. And when a judge asks a question, you must be able to immediately give him the citation. He'll go gaga over you. That is how you develop your skills. That is how you start endearing yourself to the judge. That is how the judge will always be more attentive to you. In fact, let me give you one illustration. Years back, there was one judge, very stentorian. This was hardly, I was hardly about 7 years in the bar, 7 or 8 years. I had some 3 juniors. And they were telling me that this judge never smiles. And I said, doesn't matter. And ultimately, from a district judge, he became the High Court judge also. I said, all right, one day I'll come. I will argue a matter. So I went there. I was prepared well. And for the first time, they said, we see him smiling. Why? Because every question that he asked, I had an answer. And I presented it so well that he appreciated it. He was one of those persons who wanted the lawyer to be fully prepared. Any laxity, he would frown upon you. So that is what every lawyer must do. Be prepared, read well, know the law completely, read the facts. You are better off, and the judge will, appreciate you very, very much.
The last question we will like to take, like you always feel initially the difficulty is you have lack of knowledge, and at the same time that library is also not huge to understand that. But yes, you say the belly is there to push the things forward. Because today only I was reading the article, they said it's not like one size shoe which fits all. They said that Virat Kohli is an aggressive captain, whereas Rahane has shown it in a different form, and he has also produced the results. The question is that one should know about his strengths and weaknesses and where one can improve upon it. But like you said, still the style of placing the arguments in any case, there has to be one creation, or even in the drafting sense, we all say that you have to place the facts. But how do you place that? How you actually place both facts and the legal submissions simultaneously while drafting it, number one. And number two, one experiences as one grows in the profession is that in the evening, where is the time to meet the clients, it's also time to read your tomorrow's brief. And then if you book a case, then you have to ensure that it is also filed tomorrow. So how do you maintain within, because you reach your office at around 5:30, and even if you are in the office, nobody's like Mr. Holla who is in the office till 2 p.m. Normally offices close at 8 p.m. or 8:30 p.m. or 9 p.m. How do you balance all these three?
It's very difficult. Let me tell you this. Every successful man has to pay a price. And that price is, I was very fond of lot of reading, general reading and all that. Now I have no time because, the briefs take, more time for reading than, my general reading. Family takes a lot of time. You have to, be with the family. What happens is, invariably, and this, I'm sure, every successful lawyer has found this. Invariably, you will have some marriage to attend. And when you are about to go, some 3 clients will walk in and 3 lawyers will walk in. And then, you are there till 11 o'clock. You will miss the reception and your wife will berate you. This happens. But then this is the price you pay. As I think, I did mention this also. One of the software Mughals, when he retired, he said, 16 hours, office was my home. This is what happens. You have no choice. It's like, as somebody said, it's like riding a tiger. Moment you disembark, it will devour you. And Justice Hidayatullah in his Mama's writes very, very, very beautifully. He says, it's like cycling. Moment you stop pedaling, you will fall down. So this is what it is. Ultimately, what is it that you want in life? You want success, then you have to pay a little price. You don't want success, doesn't matter. You can be like anybody else, run of the mill. There are so many lawyers. There are in Bangalore, we have some 15,000, 20,000 lawyers. But at the top, there are hardly some 20, 30. So that 20, 30, why have they come there? 20, 30? Because they have put in hard work. Their timings go on till maybe 10, 12, 2 o'clock. No choice.
So if I have to sum up the way you have said, you mean to say that success is because that you stands within that success. So the success is, you cannot achieve the success until and unless you have the desire. And I'd also read at some place that dictionary is also one of the places where the hard work comes before success. So meaning thereby one has to do more hard work than to achieve the success. And thirdly, as you rightly said, that you have to actually maintain the balance within the society. It's commonly said that life is just like a juggler in a circus, where he maintains the 3 balls. If he drops one of the ball, that is the family, the life, and the health and success. So you have to keep on juggling, like you said, the cycle. Then only the success would be there. So
in fact, let me tell you this. Every vacation, I'll take out my family, take my family out. At least that way I try to keep them, happy. That's how you'll have to do it. Ultimately, as you very rightly said, it's juggling. There are 3 balls or maybe 5 balls. So you have to keep juggling. And you have to keep everybody happy. You have to keep your clients happy. You have to keep your colleagues happy. You have to keep your paralegal staff happy. What do you do? And sometime, somewhere, you'll have to pay the price. In fact, COVID-19, 6 months, we didn't have work. All of us, all lawyers. So what we did was, the partners here, we said we will not take the salary because we didn't want, the youngsters, the paralegal staff, the other juniors, whether they be senior juniors or junior juniors, we didn't want to cut their pay or their bonus or their increment. So we said partners will not take the salary. So we didn't take the salary for about 6 months, 8 months. Now, of course, we are slowly limping back with some cases. So this is what happens. Ultimately, one thing that you must always remember is money is not the whole everything. Today you may earn money, tomorrow you may lose money. I think I did say this about Alexander the Great. When he was about to die, he said, let my palm face the sky when you take me to the burial ground. We don't take anything up. We must keep everybody happy. I think, if you spread happiness, ultimately, it is your mindset. You can be happy with 10 rupees. You can be unhappy with the crore of rupees. Spread happiness. Make that as your life ambition. I think, you will be a better person and you will be a happier person.
Thank you. And we will part for the day. But like you said, I was quite astonished. You were saying limping back to normalcy. If people like you are limping, it says that everybody wished that they could have that limp what Mr. Holla had. It just reminded me, there's a common saying that there was one man buys a car, and after 2 kilometers, he finds that there is no engine, no gas in it. He opens up, he complains to the company. He says, what's this? You have given the car without the engine. He says that it was only running because of our goodwill. So if Mr. Holla has a goodwill, I believe that if we follow all your path, we all can achieve that goodwill and success. And thank you, sir, for sharing your insights. And at least we have, from one session, besides taking everything, now we have learned that we can bring you on this platform so that regret of yours does not continue for long. We will help you to cut that regret. Thank you, sir. And tomorrow's session would be arrested detention. under the Code of Criminal Procedure by Dr. Vijay Lakshmi, an assistant professor down south in Madras of Seoul, Tamil Nadu University. Namaskar, Jai Hind, and sir, it is always a pleasure connecting with you on the platform. It's always insightful session from you. Thank you. Stay blessed.
Wish you all the best.